Well, good afternoon, everyone. It's 2 o'clock. We're going to go ahead and get started. Thank you for joining us today for the Small and Rural Libraries Forum Meetup on the topic of dates and calendars. My name is Sherry Waldrop. I'm the Forum Manager for Small and Rural Libraries, and I'm also the Director at Allerton Public Library. We host these virtual meetups on topics that are chosen for you and by you. It's a place for conversation, crowdsourcing solutions that specifically work for our library types. And I do understand there may be more than just small and rural libraries here today. That's fine. We welcome anyone and everyone to any of our virtual meetups. Later on, I'll talk about a couple that we have scheduled later on this spring. Please note that we are recording this. You would have seen that little pop-up on your screen. On Friday, the recording will be posted on the SARL website, which is on the ILA website. So let me tell you a little bit about our speaker. Most of you recognize his name. As I told him, I have certainly heard of him, but had never met him before. Phil Lenzini is an attorney in Peoria, though he's not really in Peoria right now, but he's with the firm Heil Royster. As general counsel, Phil represents over 200 public libraries throughout the state of Illinois and the Illinois Heartland Library System. And it sounds like you had assisted local governments, cities, school districts, park districts. Phil's done lots of things. You can read his full bio on the Heil Royster website, and the link is in the chat. As we go along today, Phil's probably going to talk for a bit, and then he's going to leave lots of room for questions. If there's something that you want answered, you can throw it in the chat. If it needs to be answered right away, maybe raise your hand. And Kristen, who's at ILA, and I will be watching those things for Phil. So Phil, welcome. We're so glad that you're here today, and I am going to turn it over to you.
Thank you, Sherry. Pleasure to meet you. It's good to see all the names of people I've known for some time. And as a result, most of you probably realize that even though this is being recorded, I don't hesitate to editorialize, as you'll see from time to time. Not necessarily politically correct in my cranky old age, but be that as it may. As Sherry indicated, I'm going to allow a lot of time for questions because about the days and dates to remember calendar, which if you don't have access to, you that encourages me or requires me to do that every 2 years. And then I'm going to turn to what counts as new legislation. On my list, I've got 4 bills that have become law that impact libraries, some more than others. And I want to throw some comments about those bills just for your general edification. And I'll forgot to turn my phone off. So to start with, the days and dates to remember is not actually my favorite document, but I've been doing it about 30 years, it seems like, after the state library lost its lawyer and didn't do it anymore. And it was in such demand by library directors. One of the things I don't necessarily like about it is that it lists statutory or legal deadlines. And I don't like to work specifically on deadlines. And when you're doing up to 200 libraries, if you wait till deadlines, you're certain to miss. So I like to work in terms of appropriate time for tasks rather than wait till the actual deadline. That's one of my challenges, but most everybody that uses the days and dates to remember document understands that they're deadlines and reacts to those. Secondly, I get a lot of questions about that calendar. And so it tells me that there are confusions and concerns about that. I'm going to single out, other than that concept, just one or two to talk about today, just to give you an idea. I realize it's highly thought of by most directors, especially the smaller rural directors. But again, the cautionary note is use it to guide when you're doing things in advance of those deadlines. Um, you'll see that probably the first page and a half are now a bunch of warning notes. Those have grown up over the year to try to clarify what I call the confusion or questions I get, and include the one that I'm going to talk about a little bit more detail in a minute. What I call the building maintenance tax. Some of you may call the 2% tax. But before I go there, I'll point out the obvious that there's really three calendars for the three types of libraries. Local libraries being the first, city, village, and then, or municipal libraries, if you want to call them that. Then a calendar for the township libraries, since they're materially different schedule. And then finally, the library districts, which is what most of you today are, um, being the sovereign units of government. So to start with, don't look and don't bother with the calendars on the types of libraries you are not, although I do get questions from people that make that mistake. Um, the There's only a note, by the way, I'm going to digress to say there's only a note on there regarding the two types of trainings, FOIA trainings online and the OMA, Open Meetings Act trainings online at the Attorney General PAC office. I happen to know that those online trainings, the new ones for 2026, will be up on their website, they promise, next week. So for your FOIA officers, hopefully every library has a couple of those, and the Open Meetings Act designees, one is required. Hopefully you got a couple in case the person ever goes into the hospital or on vacation. Those have to be annual trainings if you're following the law, and you print your certificates of completing it. I always do mine the first part of January just so I know what they look like and the questions look like. But I wanted to at least alert you, uh, now that we're in January, that within the next end of next week, they're supposed to have them up. If you went there today, you'd find the 2025s, which don't count. So let me turn to the building maintenance tasks. The fundamental concept, hopefully, most of you realize, or certainly if you use that 2% tax, is that it has to comply with what we generally call the backdoor referendum requirements. And what backdoor referendum requirements normally mean is that the board adopts an ordinance, but their authority to do the tax requires them to publish a notice in the paper, wait 30 days for any citizens, up to the minimum requirement is 10% of the voters, to file a petition. And if such is done, and it's very, very rarely done, by the way, I've had about 4 in 5,000 examples, then the board can either rescind the ordinance and or put it to an election. Now that's a sketch of the overall rules, and I'm going to comment a little bit more about a couple of those in a minute. But what happens on the days and dates to remember, and pointed out in a warning note, is that the timing is all in reference to referenda dates, as if you were going to have an election, as if you were going to have petitions filed. Well, you should know, if you're in Illinois, most of you would know, that we no longer have spring elections in even numbered years. So, for instance, here we are in 2026, there will not be a spring election. I'm sorry, I got it backwards. Um, the change in Illinois election law was that in odd numbered years, we have the spring election. That's when your library trustees are elected, as an example, or the school elections are. And we don't have a fall election in odd numbered years. In even numbered years, we do have. You'll, I'm sure, see that we're coming up on election considerations, but all of the dates in the days and dates tie into the various election opportunities. So, one of the calls we get very early in the year, usually like July, is we've missed the deadline to be able to adopt the ordinance, put the notice in the paper, wait the 30 days, decide if we're going to have the um, ordinance tax and therefore need an election when we don't have that fall election. For instance, this would have happened last year in 2025 that we got those calls. Well, what that misunderstands is you don't have to use the fall elections either year, any year actually, and I don't recommend it anyway. Use the spring elections. Now, some in odd numbered years, that's April when I say spring, and in even numbered years, that's March, where it's basically a primary either for governor or for president every other year, which most of you would know it by that, by the gubernatorial or presidential primary. Now, so if you look at days and dates and you see those deadlines in July, they're accurate. They're a proper characterization of the statutes and the calendar timelines, but they're just not pragmatically necessary for you, and I don't recommend it anyway. So that's a confusion. Hopefully, will disappear. Now, let me dig deeper at the risk of confusing you. Is in no way would I ever recommend that you conduct a referendum on the building maintenance tax. So if you're one of those two or three people that in 30 years got a petition, you would rescind the ordinance, no doubt. Now, the reasons for that conclusion and recommendation are as follows. First, it's a 2-cent tax, 0.02%. So it's a modest amount of money, minimal amount of money. In fact, I've never had a client conduct a tax increase referendum for anything less than a nickel, 0.05. Most would be 0.10, and some are even more than that. So you're going to waste a lot of time, energy, and money. You don't want to do it for 2 cents. Second, it's a 1 year, it's an annual, every year levy choice that you make. So for building maintenance referenda, you'd be, if you didn't follow my recommendation and went to an election ballot, you'd be voting on 2 cents, good for 1 year only. I can't imagine anybody that would want to waste their time and energy on such a measly question. I say to people, if you're going to vote on taxes, at least a nickel or a dime. And as some of you know that have already had referenda on taxes, if you do a normal tax rate increase, it's good forever. So that nickel isn't just for that first year, it's for any length of time. And that's far more worthwhile. And then the final part of that analysis of why you never want to vote on the building maintenance is the amount of money that's the 2%. If you rescinded the ordinance and didn't do it 1 year because you got petitions, is useful most of the way if it was liability funds, what I call liability funds. Some of you call it the tort or insurance tax funds. And that, as you should all know, isn't a referendum, even a backdoor referendum tax. You're authorized, if you're not tax capped, you're authorized to use the liability levies. And virtually all non-library governments, schools, cities, villages, park districts, everybody I've ever seen uses the liability tax. The libraries were the slow, conservative units of government in Illinois that only started using it when the last 30 years. So in any event, if you have a normal liability tax that pays your premiums and safety related expenses and 5 or 10% of the director's salary as a safety officer, those normal uses, you could raise it that 2% for that year, collect those monies, use it for safety expenses around the building. Now, it's not quite as broadly useful as the building maintenance money, but it's a lot of those same purposes. And no petitioner can vote on it, can petition it. So, in other words, it's a suitable substitute for the 1 year. Okay, that's more than I probably intended to say about the library days and dates calendar, unless you have specific questions that you want in your use of the days and dates. This is the chapter I've just kind of gotten through with days and dates. Hopefully, all of you are finished now with your year-end annual reports, like the receipts and disbursements report, the annual financial report to the comptroller would have been in this past fall, and of course is essential. And in fact, the comptroller has stepped up in financial penalties and has instructed the county clerks to get after you if you haven't, in fact, filed those AFRs, which is all online nowadays. So hopefully all of you are done with that. Let me turn to talking about some of the new laws, um, in spite of what you may or may not have heard. My favorite one, which hopefully impacts some of you, is what I call the Equalization Act amendments. The State Library Secretary of State was very fond of, and they honestly did do a great job expanding this. A year ago, there were only 17 libraries in Illinois that could take advantage of the equalization grants. And that's been raised, the estimate at least, was now 108 libraries. So almost 8 or 9 times as many libraries will be able to benefit from it. And in addition, it was for the clients of mine that got it last year, the year before, $7.50 per body in the library. And that's been raised to $17.50. So more than 2 times, about 2.5 times as much money, even for the former libraries, let alone all of these new 108 librarians. This went into effect January 1st. Since it's real money, and some of my clients are getting substantial grants by it. Um, I'm very fond of this change. I will say the one negative, if you're looking for negatives, and I don't think it's really negative for most of you, but I'm a lawyer, so I only hear the bad complaints from folks. But this, because it's a grant, does require under the law from a couple of years ago that you certify either to the ALA Bill of Rights or what I call the no book banning, no book burning or book banning policies. I don't have many clients that do those special policies, but they subscribe to the ALA Bill of Rights, which is the simpler way to achieve this. In any event, you have to do that. You have to certify that in order to get the grant. I don't know if there have been any questions about that, but that's Public Act 104-108. And I'll jump my list to go to the one that really probably doesn't impact you much. It's got a great title, the Public Officials Safety and Privacy Act. It's Public Act 102-0443. And what it does is for public officials, which unfortunately are not library employees, library board members, nothing related to the libraries under the definition of this statute. It is some county officers and certainly the public defenders in the state's attorney's office are included as public officials under this act. But basically what the statute does, and I honestly could hope that it be expanded to cover other kinds of government bodies, including libraries or school boards, is it prevents or prohibits the disclosure of certain personal information, home addresses, phone numbers, and the like, in order to enhance their safety. So you might want to keep an eye out for that. As written right this minute, it doesn't really cover or protect library officials, but I would hope that it might get somebody's attention. It went into effect January 1st. So then that brings me to the last two that are of increasing significance or importance, perhaps. At least some people think so. The first one I expect you've heard about, though I don't know if you've heard accurately, is Public Act 104056. It's the Narcan training, I call it, act, meaning that, and let me just start with the important point. This is local libraries only under the statute. Only the Local Library Act was amended by the statute. Now, the verbiage of the bill, and certainly what legislators have said about it, and certainly what the newspapers and magazines have said, is it's all public libraries. And that just is revealing to us that there are far too many people in Illinois that are ignorant of the difference between library districts and local libraries, which, if it wasn't serious, would bring a laugh to most of you, that you certainly know the difference between districts and local libraries. And having converted about 50 local libraries to districts, some of you here today, I know you're well aware of the differentiation. But these people that apparently orchestrated this statute either didn't understand the difference or didn't want to reach districts. And that's important for a couple of reasons I wanted to talk about today as it presently applies. First is the statute makes this a requirement of the libraries, meaning the local libraries. So if you're a district, this statute doesn't require you to do the important two things, which is to acquire Narcan, or item two, to take the training. And the training is complicated because it's both training to recognize the overdosed as also administering the Narcan, which frankly is fairly simple, but the training will just be rolling out. So it's a little early to describe what that's going to involve in terms of these, the proper name, opioid antagonists. So in any event, districts are not today required to have Narcan at the library or to have the training. I suspect many from my talks with libraries, districts, that many of you do have it. In fact, I don't want to digress too far, but many of you may have defibrillators or other kinds of first aid equipment, either by grants or donations. But back to this Public Act 10456, the part that I dislike the most in districts not being included at this time is the statute has some very good language in it that fully immunizes these local libraries from making the wrong decision and administering Narcan when either it isn't needed or there's a bad result of it. They are fully immunized from any victim against any liability. And that's a nice thing. It's a good thing. It's not unlike what we call our Good Samaritan protections. But since districts aren't covered by this statute, they don't have that express statutory immunity from a poor decision or poor administration. And again, I don't know if ILA or anyone else is going to push for this to be expanded for districts from just locals. I get enough of fun just pointing out, as I started here today, that the idiots that wrote this didn't understand the difference between local libraries and library districts in Illinois. So, somewhat 700 of you were sort of forgotten about or confused. But let me turn to the last statute that's in effect as of January 1st, which is actually fairly long and gets into lots of different aspects of the Open Meetings Act and the Freedom of Information Act. It's Public Act 104, 438. Many of you might have recognized it as Senate Bill 243, which is what it was originally called when it was a bill before it became law. And I got to start with the part of it that I get the most fun for. Many of you may have heard about the last 20 years. I made reference to my dog, and actually it's a different dog now than it was then. But my dog filed about 6 or 8 FOIAs every year. And you'd say, well, gosh, how can the dog file a FOIA, an FOIA? Well, it was a sort of an experiment, of course, because at the time, the statute FOIA, really idiotic in many ways, didn't require it to be a person. And my dog can hit the enter key on my computer, sometimes by plan, sometimes by chance, sometimes by interruption. But in any event, you'd be surprised. Now, he never filed any FOIAs against libraries. Only idiots file FOIAs against libraries. I'm sure many of you heard me say that, editorial mark, because after all, many of you are reference folks, and that's what you do, is provide information to folks that want information. So in any event, if a person really wants information from a library, they wouldn't reduce themselves simply to a FOIA request for a specific record anyway. They would just call out a human being. So back to my dog. He files these requests. And as of January 1st, he can't do it anymore because the first big change, in my view, of Senate Bill 243 was for the first time in over 20 years, you have to be a person to file a FOIA. And the unit of government, such as the library, can actually take steps, ask, inquire, seek proof that the requester of the FOIA is indeed a person. Now, it's true the legislature didn't write this bill, that language, to keep my dog from FOIAs. They wrote it to keep robots, bots, or other artificial AIs, whatever's, filing FOIAs with you, that it does indeed have to be a human being. But that's something that you need to keep in the back of your mind. If you have reason to think, or because of the type of request or what you've heard elsewhere, and you need to investigate or make an inquiry of a FOIA requester, that they prove that they are indeed a human being, you can do that under this statute. And hopefully you'll be reminded that it's the Phil's dog provision. Then the other thing that's part of that provision is that if it's a FOIA request electronically sent to you, the request has to appear in the body of the email. It cannot be an attachment to the email. You could probably guess the reason for this part of the statute is to avoid you being hacked, polluted, phished, whatever words you want to come up with, implanted with malware by an attachment and opening an attachment from an evildoer. So you can really basically ignore attachments coming from FOIA emails until the request is entirely incorporated, written out as part of, in the body of that email. It's a nice change. Um, it did make changes to those of you that have policies for remote meetings or virtual meetings under the Open Meetings Act. And I'll digress to talk a little bit about those. Some of you, I'm sure, will remember when we had the pandemic for that year and a half or so, and the governor had declared it health. We had virtual meetings because you didn't have to have anybody present but the lawyer or the director or one trustee, and you could all phone in. Well, once that pandemic ceased, we're back to the original Open Meetings Act requirement under Section 7. And in general, those requirements are first and foremost, you must adopt a policy in advance to govern virtual meetings. So if you don't have a policy adopted, you can't meet virtually, even if you want to. So you put that in the right order of things, you would have to adopt a policy to cover them. Now, in that policy, if it follows the law, well, let's say before last year, you would have spelled out the three permitted statutory reasons for virtual attendance. And you may remember they were originally, they were that you had a medical emergency or needed medical treatment and couldn't attend. You had business, personal business that took you away from the meeting. Or three, you had the library's business sent you away and couldn't attend. Well, let's see, I think it was about a year ago, maybe just 6, 8 months ago, the legislature added to the permitted reasons, and most of you should have adjusted your policies for what I call unexpected child care obligations. That was a legitimate reason. If a board member couldn't attend physically because you didn't want a screaming baby at your board table, they could be permitted to attend virtually. Now, you remember under the statute, one of the reasons this isn't used too often is a physical quorum must be present at the meeting site. So the director could phone in, the lawyer could phone in, board members who don't constitute the quorum could phone in. And I say phone, you could use a computer, you could use Zoom like we're doing right this minute. So the technology is not the problem, but the law does require that physical quorum to be present. So anyway, that's the backstory. And what Senate Bill 243 did, and I don't know that this is going to be too numerous, but they added another permitted reason that you can put into your policy for attending virtually, and that's the reason is military service. So if you've got a board member that's like in the National Guard and he's being sent to Chicago for the riots or some reason, Minnesota, then that could be a reason now for them to attend a library board meeting virtually. But it is a change. They added under this act an immunity for the FOIA officers and any public official for that matter who discloses records under FOIA based on a PAC, the Public Access Counselor's determination or letter. So if you rely on that as a reason for your disclosing information, you'll be immunized or protected from any liability. And then I guess the last two aspects I'll mention at least under this summary, they seem kind of foolish to me, but they are improvements. The statute says that junk mail, and I think you all know what that means, that junk mail is not indeed a public record because it sure looked like it would have fit under the original public record definition under FOIA. So now it's excluded and it's defined what junk mail means. So you don't have to collect it, you don't have to keep it, you don't have to turn it over or search it. when it comes to FOIA. So that's kind of nice. The legislature hasn't done many of these cleanup steps, so everyone we see is, as this bill had several. And the final one is if you have, and you should have, the required, what I call FOIA provisions in a policy. Now, the FOIA nowhere says you're required to adopt a policy. So don't misunderstand me. A students would never say FOIA requires you to adopt a policy. But many of you have a policy because that was sort of the intelligent, economic, efficient way to gather lots of pieces FOIA does require into one spot. So the original administrative ready reference, which I want to mention in a minute, did have a model policy that included many of those things. You may have known it or remembered it by examples. You're supposed to have an organizational chart posted. You're supposed to have a summary list of the types of records and documents you keep, like your meeting minutes, your agendas, your budget ordinances, all your ordinances for that matter. And this policy model included all those kinds of things. You're supposed to have adopted and published or posted the fees and charges for FOIA that apply. 15 cents a page for copies over 50, special cost for color copies provided if requested, cost for certification. All these sorts of things are required under FOIA. So they were all gathered into this model policy. And I think, let's see, they would also require the statement of who the FOIA officer is, who makes rulings on turning over FOIA documents, how those decisions can be reviewed. So all of these things that are required by the statute uh, most commonly are put into a policy that the board can then adopt and update or amend from time to time. Now, that policy isn't specifically required, expressly required, but it is the smart way to do it. So, with that background, Senate Bill 243 comes along knowing that many people have such a policy. And it basically says you can post that policy on your website if it's maintained by a full-time employee, of course, but you can post that on your website and you do not have to have it posted on your bulletin board. So that's not a huge change, but in the context, it'll make sense. So my kind of concluding comment before I open that specifically for questions is I made a reference just now to the administrative ready reference. You may have noticed that because that's a very useful tool, has been a very useful tool over 40 years by small rural libraries, especially because that's who it was designed for originally. That was taken down by the state librarian about, I'm going to say 3 months ago. I've lost track exactly when. And since I've written every edition for the 4 editions they've had, I understood that it was out of date, hadn't been changed for 6 or 8 years. There were some errors on there, some things that were still good on there. But in any event, they took it down when they hired me to redo it. Well, actually, they hired Illinois Heartland and Library System, and they in turn hired me to do it. So it's a massive project. And I think by sometime middle of this year, we'll have completed it and it'll be available in some way. I'm not sure how it'll be distributed. I don't think it's going on to the state library website, but again, I don't get involved with those details. I just get involved with the forms and the policies. But it'll be a reference point again for many of you, I hope. So let me open it up. Have I missed questions? I see some floating hands. Um, and actually, I saw Lori Rich had a hand up a long time ago and then it disappeared. So I don't know, Lori, if that was a question you just held off on or.
So if anyone has any questions, feel free to unmute yourself and ask your question to Phil, or you can stick it in the chat. Whichever you prefer is fine. So Phil, I'm not sure if you're seeing the chat. Someone is asking if the Narcan training is a yearly requirement.
Yeah, well, we don't really know. I'm reading the statute and I want to make sure it's a great question, but and it lets me dig a little deeper into the statutory language in this sense. Again, this is local libraries only, but something you certainly may care to be informed about. The training that's required is effectively governed by the Department of Public Health in Illinois. So you can go on to the website of that department. It's supposed to be a free resource, and they are definitely required to conduct um, or actually approve organizations to conduct the training. But until or unless they specify, the statute itself doesn't detail. It actually doesn't detail what the training's supposed to include. It sort of defers to the Department of Public Health to figure that part out when it's approving the organizations to do the training. And I'm sure that will include the timing in the sense of whether um, it is an annual requirement or how frequently it needs to be updated or kept up to date. So at this stage, we really can't answer the answer. We really can't answer a very good question of whether it's going to be annual. So I defer to the Department of Public Health, which I suspect I haven't visited their website to see what they even have on it at this stage, but I expect them to be fairly quick in their rollout. And there were a lot of organizations. The hardest part probably is that Narcan training is really fairly simplistic. So I don't know if it'll be done through like local fire departments, even or emergency response systems, or law enforcement for that matter. So there are a lot of potential organizations or associations out there that might arm themselves to do the training. So great question. I'm sorry I can't give you an answer other than to defer to where the answer is going to be found, which is the Department of Public Health website. And that's okay, Lori. It's always good to hear from you. Um,
So Phil, I actually had a question. So what you were telling us about going back to the Narcan, I it said local libraries. And so when most people think of a local library, they think of, the library that's, nearby or in their town or so I'm a district. So you're saying technically that because I'm a district library that I don't fall under the auspices of that act?
True. Um, Again, I love showing librarians books, and most of you probably either have this is the current edition of a great ILA publication of the Illinois library laws. And if you have that and you ever want to look because you doubt me, 75 ILCS 5/101. The very first page of that book, our local library act, that's a proper name. I didn't make it up. The local library act. And many pages over after library systems, you get to the Public Library District Act, and it actually was 1991 as amended that I helped work on. And that is a different animal. It might as well be park district or school district. And if you have the Local Library Act, that's the statute that was amended by um, Public Act 104056, the one I was just looking at for the Narcan question. And that statute amends only the Local Library Act. And the Local Library Act only applies to city, village, and township libraries. I'll give you a different example. Again, most people don't know this, honestly, is I think it's ignorance, but they just don't know. The city of library, like Peoria, Bloomington, uh, had 9 trustees appointed by the mayor. Uh, Districts have 7 trustees elected. Now, to really confuse everybody, 2 types of local libraries, village and township, also have 7 trustees elected. So even though the Local Library Act has 3, city, village, and townships, it divides, when it comes to boards, trustees, the number and the manner of selecting them. But anyway, that's just the fun of Illinois law. This is over 100 years old, what I'm talking about. So it's not a modern problem. But yeah, if you're a district and you have 7 trustees elected and you're under 75 ILCS 16/1-1, this Narcan rule and the immunity and the training did not apply, did not yet be amended. Now, again, I pointed at ILA's public policy committee. They may very well um, take steps to correct this or educate folks and get that amendment reprinted to apply to the local, or excuse me, the Public Library District Act. But as of now, those are 2 totally different laws.
Fascinating. Thank you. But I have my Narcan available, even though I'm a district.
Well, yeah. Now and that's perfectly fine. I'm not
Yeah.
I'm not recommending either way. You're what we would be calling a gratuity,
Mm.
and there are a lot of gratuities out here. In fact, I don't know where you got yours, but there's a lot of free Narcan for good people who want to have it available, such as public libraries. And the training, I don't know what training you've actually gone through there, but basically, I take that it's not that complicated to be able to do an acceptable um, recognition and administration of it. And it's relatively safe. I think I haven't seen any cases of, let's call it a Narcan victim who's who may or may not have been overdosing on opioid, uh, administering Narcan. So I don't know that any serious results. Let's see. Alice says, I know I read somewhere districts would be included by January 2027. That could well be. I mean, I could almost say that would be good news in the sense that, again, that immunity clause that it ends with immunizing library officials or employees that administer it from any liability, that's a good thing. I'd fight that, Sherry, that you're immune under Good Samaritan principles, by the way. So it's not like you're on a tree limb or anything, but it's nice to have that express statutory change if that's included with what Alice is talking about. And, I don't, let me go back to my comment about ILA. It's not ILA's job to fix statutory confusion, errors, and mistakes. But, a lot of what they would debate at the committee, I'm sure, sort of relates to that in terms of the improvements on statutes and amendments they've pushed. So God bless them if they can achieve it. Of course, I'm not going to get too dependent until I can get somebody convinced that the board vacancy statute needs to be fixed and a full year of missed attendance has to happen before you can declare the seat vacant. I sure think someday I'll live long enough that we get that statute changed to say maybe 90 days, heck, maybe 6 months of missing meetings. But I've got a lot of libraries that are haunted by that empty seat that we can't declare vacant because they haven't missed a full year yet. So, anyway, other questions? I appreciate all of you coming to spend an hour with me, but I honestly thought some of it would be motivated by questions you had. Don't save the great questions to call me, later today or tomorrow after we get, unless they're super private.
Right. This is free access to Phil.
Yeah, yeah.
I have a question because I'm such a rule follower. I'd follow all the rules of the days and the dates and the deadlines and things like that. My question is what happens when people don't? Like this, you mentioned, and I saw this, the comptroller's office, if you didn't get your, FAR in by the end of December, you were going to be fined, so obviously that was something. But if it's something else, if you don't have your list of trustee meetings posted or determined or whatever. So my question is who is it that is monitoring these things, and what are the repercussions for people who don't do things by the time that they're supposed to?
Well, it's a great question, but it really just shines the complexity of it because if there's 1,000, and there's more than 1,000, by the way, I'm not exaggerating on this part. If there are 1,000 rules, they're all different as to what the impact is when you violate them. And in fact, I try to explain it usually that some are far more important than others. And it's usually the penalty or the result that drives the priority or the importance of it. For instance, especially for the districts, but even some locals, when it comes to budget and appropriation ordinances and tax levies later in the year, they've just finished a few months ago, finishing up. Under statewide average, 93% of library funding comes from property taxes. Now, I'm not saying we're proud of that, happy with that, and love that law. Put that aside for a moment. But 93% of your money on average comes from property taxes. You ought to do them, or that's why I do 100 of them for libraries, districts. You ought to be pretty careful doing them so you get that money. Otherwise, next year you won't have any cash to operate. So that's a pretty severe penalty. Now, it's true that depending on the defect you've done, you might not risk all of the levy. You might only risk part of the levy. But it's not normally the thing people want to gamble with. We have some built-in protections. Often the errors require tax objectors to be triggered, but sometimes it's the county clerk can trigger it or the state's attorney, and I had those battles. But again, that's a pretty serious one. I usually tell people if they screw up everything else, they better not screw up their budget and levy, or even if they have to go through the city, village, township to get their levy, because that's so critical, for at least from my point of view. Now, a different example, and let me go back to that AFR comment. Most of you, in fact, the small rural libraries, none of you should be required to have an audit report done because you have to have $850,000 of revenue. And I'm sure none of you have that much. In fact, there's even a bill to raise it to $1 million someday. So those are the people that really require an audit. And I was more familiar when I did school districts and city work because most of them are over that 850,000 mark. And if you did not file the audit, this is, let's say, go back 25 years, nothing much happened to you. Then the comptroller had a letter writing campaign and came up with a nasty list, that's what I called it, of all the people that didn't file their audits. That didn't make, that didn't move the needle. It didn't get many more audits filed. So about 10 years ago, they stepped up the penalties. And it's been, I think, the last 6 years that they actually have a financial penalty. And it's serious money. And particularly serious, I don't know if they learned it from the IRS, because it keeps going up. Like the first 7 days you're late is one price, and the next 7 days it's double that, and the next 7 days is double that. So there's serious financial penalties. Now you can appeal it and get it waived if you promise to be a good boy, and I've done many of those when I used to do cities. That's the analogy they use with the AFRs, that originally it started off with a nasty list, and nobody really cared if they were on the list or not. First time they ever did the list, over 50% of the governments didn't comply, didn't file it. They built it up. I don't know the statistics nowadays, but they're up above 80% compliance. And they have a financial penalty that they will at least threaten, if not administer, if you don't file it. But this is similar to the annual report of receipts and disbursements that must be filed at the county. Some people call it the treasurer's report that must be filed at the county. You've got some county clerks that say, if you don't have that on file here, we're not going to give you your taxes. So it triggers a very serious penalty. It's mostly to get you to comply and get it on file. But if you don't, if you want to play that gamble with certain county clerks, they'll they'll hurt you. Um,
Phil, Katie
so
has a question in the chat.
yeah, I was looking at it, and so anyway, the penalty question, it just varies so much with what the result is. If you don't publish the meeting dates on your wall at the start of the calendar year or fiscal year under that requirement, you're at the worst that's going to happen right now is you're going to get a nasty letter from the Attorney General. Um, what sort of notification does the public need to for a new trustee can be appointed to the board? Well, actually, I'll take this to be a district, Katie. There's no notice that's really legally required. In fact, there's no real procedure for appointment of trustees. You can back into it in a sense by what the requirements are to serve as a trustee. You have to be up on your taxes. You have to be a resident for at least a year in the district. So if you look at those sorts of rules, you have to be above 18 years old. You can sort of figure out some fundamental requirements, but it doesn't say you have to be literate and can read, or you're a high school graduate or a college graduate. It doesn't say you have to have an interview of candidates. Um, so a board can actually take whatever steps it wants to get a warm body in the seat to constitute your quorum. And of course, in districts, they're eventually elected. And as we've been known to some of the officials we've elected, they don't really have to be too competent or qualified to be a candidate. Um,
Yeah, and just
and no, let me back up, Kathleen. Great question. Uh, totally rational, but unfortunately totally illegal. The hierarchy is the Constitution governs everything. Federal law is highest, of course, but coming to the state constitution, then state statute, and then local policy. That's kind of the hierarchy. So you can't have a policy effective for a shorter time of non-attendance um, to override the 1 year under the state statute because the state statute controls. Now, it's true pragmatically, not legally, that a trustee who's kicked off for missing 3 months of meetings may never challenge it and they may go politely on their way. Um, but that's not legal, or you're not going to get legal authority. If, for instance, they challenge that declaration of vacancy, and some of that happened up north in the suburbs, and the courts it takes them no time at all to rule for that trustee who's been missing all those months. Of course, it's a non-paid position, so sometimes they disappear. But no, local policy never overrides state statute when the state statute is clear and express. Um, the I didn't finish that other question about does the considered person need to be named in the agenda or just during the meeting prior to the vote? It's a great question because I'm not sure the Attorney General or PAC and I totally agree on this. They don't read the agenda requirement of the Open Meetings Act the same way a third grader or anybody that speaks English or me reads it. Because the statute says the general subject matter of the action must be listed on the agenda. And we know what general subject matter means. So if you said on your agenda, appointment of a board vacancy replacement, that seems to me to be the general subject matter that's the action you're going to take, or words like that. And to then declare, like an attorney general would, that you got to name the person in that sentence on the agenda to comply with the agenda requirement, to me just isn't reading English correctly, because that's not general, that's specific. But they would say that because they're politicians. And most of them don't have a lot of experience in practicing law, by the way. I won't say they're right out of school, but they're good people. They don't beat their kids anymore. Most of them have library cards. But they plainly believe the agenda requirement, the statute I just paraphrased, was put into the Open Meetings Act to fully inform your public. Whether the public really wants to know that or not, or ever looks at your agenda or not, it's posted, got to be posted through the glass so it could be continuously seen 24 hours a day, 7 days a week for the 48 hours prior to the meeting. By the way, I'm digressing there on that requirement. They've been very hot on that. They have also, though, said if you post the agenda on the website 48 hours in advance, that satisfies the continuously available requirement. So, in any event, definitely has to be listed on the agenda. I would agree with that. But it doesn't necessarily have to name the replacement, it seems to me that's defensible. But that's only what I believe. That's not what no court's ever ruled on it. And that's not what the Attorney General's view would be.
Okay, well, Phil, we're nearing our 3 o'clock time. There are a couple of more questions. I just wanted to let other people go. You're welcome to stay on. I think there are about two more questions that we want you, if you're willing to answer.
Yeah.
But I also just kind of wanted just to make a lot of people are thanking you in the chat, which is great. And we do thank you so much. Just want to remind people that this recording will be up on the SARL website, which is on ILA's website tomorrow. There are some upcoming meetings for the SARL Forum, one in February. And in March, we have another meetup with Amanda Doherty on the imposter syndrome. You can find that information as well on the SARL website. And everything that we have and do is open to any ILA library worker. So just want to say those things, and then we're going to get to these last questions, Phil. Christine had a question about, are there penalties for not filling a trustee seat in a timely manner? She is a village library.
Well, I see that, and I want to talk about that, but I want to go back and just, I honestly didn't finish the district library trustee question similar to that a minute ago. There's no credentials or steps that you have to take up to the appointment, but most of you should know, districts, that the statute was amended, I think, 3 years ago, where if the library district board does not fill the seat within 60 days, you have to file a notice with, well, actually, you're supposed to file a notice of the vacancy with the state library. And eventually, the state librarian appoints a resident from the area to the district board. Now, I don't know that they've done that anytime. The statute came up because of a problem up north where the board kept getting a 3-3 vote, and they couldn't agree ever on that seventh person. And they literally hated each other. So some legislative solution had to be implanted in that circumstance. And even there, I don't think the state librarian filled the seventh seat. I think it ended up election time by then, but that's another story. That law doesn't necessarily apply to the context she's talking about. When I hear these, and I hear these all the time, and it's especially scary when you get a board of 4 or 5, which you're dangerously close to losing your quorum and not being able to take legal action without it being very dubious and challenged and easily challenged. So by anybody who wants to close your library down. So you need what I call a warm body. And I know everybody that calls me about this says, we can't find anybody, including a warm body, to fill that seat. And they just aren't, unfortunately, properly motivated, at least the way an old crusty lawyer like me would be properly motivated. Because there's a human someplace. I don't know if it's the director's spouse, child, trustee. I know they're not legal, by the way, rules on nepotism that we don't want the director's spouse on the board. That's all bogus, by the way. I have a lot of examples where that's not been that bad. But if it's the warm body we need to fill the seat just to constitute a quorum, you're going to have to find somebody. They may not be literate. They may not want to serve very long, maybe just till the next election, but you're being too picky. And I say that with full knowledge that you're not really being too picky. You really want the kind of library trustee candidates we generally have in Illinois, which are the greatest people in the world. They ought to all go to heaven if I have my way. They're well educated, thoughtful, care about their community. They don't want to burn books, blah, 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 all those good things. But it is hard to find an uncompensated public servant to serve even that once a month meeting. And very often, I know how hard it is to find trustees. And sometimes you really have to open it up to begging if you need to, a card holder, somebody that cares about the library, somebody that understands they're only going to serve a short time because they're not prisoners. They can certainly resign, retire, or not attend. So that's the best answer I can give you. The fear is that you'll lose a quorum. And I want to go back in terms of the meeting date ordinance. The normal meeting date ordinance answer is it's posted on the board where you post your notices. Doesn't even have to be continuously available through a window. Just post it on the board or your website and left all year. You don't have to pay. When I say publish, that means pay a newspaper. You don't have to publish the normal meeting date ordinance. One time you do, and that is if during the year, first month, last month, during the year, you get the idea that your meeting dates, let's say it's the first Tuesday of every month, isn't working for some reason, and you want to change it to the third Thursday of the month, all of the rest of the meetings of the year, whether that's one more, 12 more, whatever, all the rest of them are going to be changed. Under the Open Meetings Act, that change must be announced 10 days in advance. You must publish that notice. That's the one and only time you have to publish the meeting date. That's, if you want to call that your revised meeting date ordinance, in the newspaper. And that's not changing this month's meeting only. That's changing all the rest of them for the year. Okay. That's under the Open Meetings Act where that's laid out. maybe, Sherry, you can help me. I'm not scrolling very
Yes,
well
so
for
there's
some
two more
reason.
questions. One, village library that wants to know if there's penalties for not filling a vacant seat. They have had a vacant trustee seat
Yeah,
for about a year, she says.
yeah. That precise defect of having a vacancy for a full year, there's not a penalty directly and precisely. It's that you're running towards the loss of the quorum, what I was talking about with four members. You don't want to get to four. That's far too dangerous because then you can't conduct, theoretically, you can't approve payment of your salaries. So that's pretty serious. But anything else you want to do as a library board without a quorum, which for well, for libraries, townships, and districts is four of your seven. For cities, it's five of their nine. So you want to get it filled before you get too low. 6 member boards, we don't have a lot of history of tie votes in libraries, 3-3. So I would point that out, but as a risk, but it's not a very serious risk. Most votes in libraries are 7-0 or 6-1 by all means. And then was there another one here too?
Yes, so the last question is, and this was recently brought up in the Illinois Heartland Directors listserv, and it has to do with trustees. This kind of came, somebody said from the state library, that library trustees should have library assigned email accounts and not use personal email accounts. So Lori was wondering,
Yeah,
is that a new thing? And is it more of a recommendation from the state library? Is it a law? So I think Lori's just trying to get her hands on what's going on there.
yeah. It's I guess you'd classify it as a recommendation. But the state librarian recommendations do matter a little bit. I mean, we maybe not as important as mine or the attorney general's, but they're pretty important. And we like to follow them because they're usually well thought out or have a rationale behind them. So I wouldn't ignore it. Um, let me put I'm not saying this is his rationale, but I bet it is. The reason you want, um, let's call it an official email address for your trustees, is that it segregates for purposes of FOIA requests, for that matter, legal discovery deposition subpoenas. We don't have many of those in library land, but even for that, um, when you get a FOIA request for records of emails between board members or staff to board. Again, I know a lot of you don't get these, but believe me, it does happen in every district or local library director that's gotten one could share their catastrophes with you. When you're talking about a lawyer or a FOIA officer investigating a trustee's private email accounts, heaven knows what all you're going to find. And that's only arises from the ignorance of not segregating in advance, prophylactically segregating it to be safer. All of your library business, emails sent to the board members by the director, emails sent to the board members by citizens. The first page of your website is supposed to have an email address where your directors can be or your trustees can be reached by email from a citizen. If you don't do that, you're not in compliance with the Open Meetings Act. So basically, that's the rationale underlaying it. It's just the safest, most sensible way to proceed. And having said that, let me back up and say, I don't know how many email addresses most of you folks have, but they're free with Google Mail and Hotmail and AOL Mail and all the mails of the world. I've got about 5. Now, it's true, most of them I don't use for any purpose, and I'm not subject to FOIA quite the same way you guys are, but That's the rationale, is a good system that you can then uh, search for FOIA requests or retrieve and publish to the requester is a lot less offensive, embarrassing, harmful, time consuming, all of those bad things. And I'm sure that's the rationale behind the recommendation.
I
So
think that
Sarah,
was,
it's you don't have to send your meeting date ordinance to the newspaper. It's not legally required. You certainly can. It's not, especially if you don't pay them and they don't charge you for it. And a lot of weeklies need text to keep their in compliance with the law. They have so much text, and if they don't make 25% of their newsprint in narrative, it's called, then they can't publish legal notices. So they can't have a weekly advertiser that is 100% advertisements publish legal notices. They don't qualify anymore. So that's why a lot of these little, there aren't many of them anymore in Illinois. They're closing down right and left. But if they still want to publish legal notices because of the fees, think of what you pay for your budget ordinance publication, hundreds of dollars usually. So they take meeting minutes, even draft yet approved meeting date ordinance. They'll take anything and publish it for free just to meet that. Now, I don't know how many are left that way, but so you can certainly give them that, but you're not legally required to. That's a gratuity.
All right, Phil, and everyone, thanks so much for hanging in there with us. Phil, you obviously have a lot of information, and we just really value your time today and all the information that you provided with us, or to us, I should say, in answering all of our questions. So, again, thank you so much for all of
Thank you.
that. Again, remember the next forum meeting is Thursday, February 12th at 2 o'clock, and the next meetup that we're having is March 12th. That's at 2 o'clock as well. You can register for both the meeting and the meetup on the SARL forum page on the ILA website. So thank you so much, everyone. Everyone be safe. Remember to join our Google group and Facebook page for updates in terms of librarians out there if you have not done so already. So enjoy the rest of your day and be safe, especially with those storms coming in Illinois.
Thanks, Sherry. Appreciate it.
Yeah, and everybody's saying goodbye too. So I'm going to go ahead and end the meeting, and you take care, Phil. It was great meeting you. Thanks again for your time.
Thank you.